Hey there all. So digital ID, it is a flurry on the socials and lots of people are asking questions. So I have put together this information to really lay out what the legislation is as of today and what we can do to protect ourselves. We'll also have a look at other digital processes like digital signatures compared to wet ink signatures. And we'll look at the processes that we can do today to not do the digital ID and not do a digital signature, but also what we're going to need to be vigilant about in the future. So just bear with me while we have a look at the legal position regarding digital ID. Now, this relates to Australia. If you are overseas, most countries are going down the same path. You'll need to look up the relevant legislation in the land you're in. So the legal position. At the moment, the legal position is that it's voluntary by law. So the Digital ID Act 2024 is the governing Commonwealth legislation for Australia's national digital ID system, regardless of what they change the name to, okay? So Section 31A of the Act sets out one of its central objectives: to provide individuals with secure, convenient, voluntary and inclusive ways to verify their identity in online transactions with government and business. I love how they use the word secure, making people think it's safe, convenient. Well, humans are lazy. Voluntary and inclusive. So we're not leaving anyone out. No one's going to get left behind, is what their spin doctoring is saying there. Now, the official digital ID system guidance confirms in the legislation the creation and use of a digital ID by an individual is voluntary, and an entity cannot require an individual to create a digital ID in order to receive or access a service. So what this actually means is no government agency, bank or business can legally force you to create or use a digital ID. If that service does adopt digital ID, they must provide an alternative pathway for proving your identity. For example, traditional ID checks, the 100 points of ID, in-person verification, certified documents, etc. I might add, though, that biometric data and face recognition is another option that they can offer, which a lot of us aren't happy with that either. Now, this principle applies across government, banking and private sector services. Now, that's what the legislation states, but let's look at the reality in practice. So, although the law clearly protects voluntariness, is that a word or did I just make that up? Voluntariness risks remain. Bit like what happened over the last 5 years. Soft compulsion. Agencies or businesses may make digital ID the default option online, hiding or making alternative services just harder to find. So I know that one of our members in Western Australia stated that he had to do some registrations for agriculture, and the only way to pay by a debit or credit card was to do the digital ID first. Now, there are other ways to do it, but it would have been more laborious and take a long time. So the path to least resistance was digital ID option only. Let's also look at face-to-face, staff ignorance, right? So service staff may incorrectly insist that digital ID is required simply because they haven't been trained on the law. Also, exclusion by design. Alternatives may be delayed, less convenient, or poorly advertised, leaving people feeling marginalised or pressured to get the digital ID to get the service that they want. And of course, at least for the next decade, there will be a digital divide. People without smartphones, reliable internet, or digital literacy may be disproportionately excluded. You know what? I would like to be in the mob that is excluded. Thank you very much. So let's actually focus on what we can do, not what we can't do. I'm all about that. So let's look at our rights when signing up. If you were told by any agency or service that digital ID is required, you need to ask directly, straight up, for an alternative pathway. For the government, for example, request manual 100-point ID check, show certified documents, or request in-person verification. Now for banks, request standard AML CTF ID checks, passport, driving licence, Medicare, birth certificate. For businesses, ask for manual document verification. The next thing to do is to cite the actual law. Quote the Digital ID Act 2024 sections 31A and highlight the word voluntary. Next, you could request written confirmation that you will not be disadvantaged or excluded for refusing digital ID. Now, mainstream men and women would say, well, if they don't agree to any of that, you should escalate, make a complaint. Now, in the programmed world, if you wanted to make a complaint about the government, you'd go to the relevant ombudsman. If it's a bank, you would make a complaint to the Australian Financial Complaints Authority, AFCA. And if it was a business, you'd make a complaint to the ACCC, the Australian Competition and Consumer Commission. The thing is, all those groups that I mentioned are attached to GovCorp, and they all probably use the digital ID to access their services down the track. So it's a bit of an oxymoron. So what I've done in this kit, I've put together some templates that you would be able to use when standing up for your rights regarding digital ID. So I've created a letter, a template. The subject of that letter is Request for Alternative Identification Pathway, Digital ID Voluntariness. And this is to go to any agency or organisation. I am seeking to access, whatever the name of the service. I have been informed that participation in Australia's digital ID system is required. This position is inconsistent with the Digital ID Act 2024, which states one of its central objectives is to provide individuals with secure, convenient, voluntary and inclusive ways to verify their identity, Section 31A. Government guideline further confirms the creation and use of a digital ID by an individual is voluntary, and an entity cannot require an individual to create a digital ID in order to receive or access a service. Accordingly, I request that you 1. Confirm the lawful alternative identification methods available to me. 2. Assure me I will not be disadvantaged or excluded for choosing not to use digital ID. And 3, provide a written response confirming your compliance with the Act. If no alternative is offered, I will escalate this matter. Now, you could list one of the ombudsmans, but like I've said, do they really hold any power anyway? Then you would just sign off, kind regards, your name and your details. I also recommend, so you're not caught off guard, to have a little script in your wallet or your handbag. And so I've put together a very quick script, because sometimes when you're caught off guard, all the information in your head can disappear. So for use when speaking to staff at a bank, a government office or a service desk, here's just a little script to say. The Digital ID Act 2024 states clearly that digital ID is voluntary. You cannot make it a requirement. I would like to use the lawful alternative pathway to prove my identity and access your service. Please advise what those options are. If you refuse, I will need to escalate to the relevant complaints authority. Now, although this is the case, and as of today, that is the current legislation, we're not silly. A lot of us have been frogs in boiling water, especially since 2020. So let's focus on protecting against future changes, because, crikey, I think that will happen. So while the current Act makes digital ID voluntary, Parliament could attempt to amend the law in the future. So these are the things we need to work together to protect against this, and there have been some really awesome posts, articles, etc. shared lately from wonderful educators and mentors in this space, and they have shared a lot of this amazing information. We need to make sure that we monitor proposed future amendments. Any change to make digital ID mandatory would require a bill to pass Parliament, so we need to track consultation papers and exposure drafts. We need to submit objections, make submissions during public consultation processes. Of course, then we need to lobby the members of Parliament. We need to write directly to your local MP senators demanding voluntariness be preserved. Support civil liberties groups, right? There are amazing groups out there. They're all banding together. We need to back these organisations, these private societies, these communities that challenge overreach. And we need to have collective vigilance. We need to move in a pack, guys. Document refusals, share the experiences out loud, and join with others to resist this soft compulsion. Now, we need to look at future-proofing clause for advocacy. So when writing to members of Parliament, ombudsman officers or public campaigns, use wording such as, I insist that any current or future legislation concerning digital ID must preserve the voluntary nature of the system as enshrined in Section 31A of the Digital ID Act 2024. Any attempt to mandate or indirectly coerce participation would be contrary to the stated purpose of the Act, discriminatory in practice, and unacceptable to the Australian people. All right. Let's take a big breath and look at the bottom line. At the moment, the law is actually on our side, in theory. Digital ID is voluntary by statute. We do have the rights to alternatives. No agency, bank or business can lawfully make digital ID your only choice for now. We do need to push back firmly and lawfully. Use the Act's wording, demand written confirmation and escalate complaints. We need to be really public about those complaints as well, I feel. Stay vigilant. Governments, I say the word may, but of course, words are spells. I don't want to put it in concrete. Governments may attempt to change this, so public resistance and advocacy are key. I don't like to step into fear. I like to face everything and rise. So I believe we are not powerless. By knowing the law, demanding compliance and standing with others, we can ensure that digital ID remains voluntary and inclusive, and that no one is excluded, marginalised or left behind. Now, a segue to that is wet ink signatures in property, banking and land title transactions. Now, Australian land dealings have moved towards electronic conveyancing via private electronic lodgement network operations. So banks, solicitors and conveyancers often state you must sign digitally. But this is incorrect. Wet ink signatures remain lawful. Electronic lodgement is mandatory unless an objection is obtained, but it's completely possible to obtain it by simply saying you are worried about your security. That is a lawful exemption. The legislation provides for paper lodgement, so make sure that you can get that option. Now, in the legislation, it's called the Electronic Conveyancing National Law, ECNL. It's been adopted in most states and territories via their own state acts. So in New South Wales, it is called the Electronic Conveyancing National Law. In Victoria, it's called the Electronic Conveyancing National Law Application Act 2013. In Queensland, it is the Electronic Conveyancing National Law. In South Australia, it is the Electronic Conveyancing National Law South Australia Act 2013. And in Western Australia, it is the Electronic Conveyancing National Law WA Act 2014. Now, there's a key provision. Section 7 of the ECNL, it states, a required dealing must be lodged electronically unless the registrar determines otherwise. This means the registrar does have discretion to allow paper, wet ink lodgement. Now, in section 2.2, the state regulation and practice directions, right? So, the New South Wales Land Registry Service, all mainstream dealings must be lodged electronically, but options of exemptions are available. See Conveyancing Rules Waiver CR2. This allows paper lodgement where ELNO cannot be used, and Victoria, Queensland, etc. have similar exemptions. You'll need to look those up for yourself about paper lodgement permits. Now, when it goes to actually lodging that, you will have to get your solicitor or conveyancing agent to do it on your behalf. The Electronic Transactions Act. Each state has its own Electronic Transactions Act. For example, the Electronic Transactions Act 2000 in New South Wales. These acts will all contain a similar clause. It states a transaction is not valid merely because it took place by means of one or more electronic communications. Importantly, they also say electronic communication may only be used where the person consents. Consent is key. Everything's always an offer. You cannot be forced to sign electronically. Consent must be explicit or implied. Refusing digital. This means exercising your rights under that specific act. Now, why does wet ink compared to digital signature matter anyway? Okay, I just thought I'd add this in here. Why wet ink matters? Number one, consent. Consent. Digital cannot be imposed. Contract law requires agreement. Next one, evidence. A wet ink deed is a true, original digital record. A certificates only, right? So a wet ink deed is a true, original hard copy. A digital record is just a digital certificate in a server. Also, you know what? There are fraud risks. Digital identity theft and ELNO vulnerabilities increase risk. Also, let's look at control. Wet ink keeps transactions within your control, not outsourced to ELNO entities like PEXA or Simply. Now, let's look at what we can do, not what we can't do, as I always say. Let's look at the exemptions process. So, to insist on wet ink for land title dealings, your solicitor or conveyancer must apply for an exemption to the registrar in your state. Now, approval is discretionary and must fit within state practice directions. For example, in New South Wales, there is the Conveyancing Rules Waiver Rule 8. It permits paper lodgement in certain scenarios. In Queensland, the Titles Queensland Practice Manual states that paper accepted in exceptional circumstances. But we can dictate what those exceptional circumstances are. Be creative. Now, banks and mortgages. So, mortgages are deeds. Wet ink is still legally valid. Now, banks will push for the digital PEXA execution, but cannot deny a lawful wet ink mortgage if exemption is granted. We do need to notify the bank in writing. You require wet ink execution and you need to instruct your conveyancing agent or solicitor to lodge the exemption. Now, a lot of the conveyancing solicitors now are stating that they accept only digital. You need to push hard on that because they know otherwise. They are maybe just being lazy or they have a programmed process. Looking at sales contracts. Land sale contracts remain valid on paper in wet ink. Platforms like DocuSign are common, but they are still voluntary. You may demand a duplicate wet ink original exchanged physically. So in this same kit, I've created a template notice to the conveyancer, bank or land titles office. The subject is request for wet ink signature execution and exemption from an electronic conveyancing. Dear whoever it is, I hereby instruct that all instruments, contracts, deeds and transfers relating to, and then you'd list your property, mortgage or transaction, be executed and lodged in wet ink. I do not consent to electronic lodgement, digital signatures or the use of third-party electronic lodgement network operators. Pursuant to Section 7 of the Electronic Conveyancing National Law and corresponding registrar's practice directions in whichever state you're in, I request that you apply for the necessary exemption to permit paper lodgement. Please confirm in writing the lawful pathway by which wet ink signed instruments will be accepted in this matter, and then you sign the letter off. So the bottom line here, digital signatures are not mandatory by law. The own ECNL Section 7 explicitly provides registrar discretion to allow paper lodgement. Electronic Transaction Acts require consent for digital signatures. No consent equals no compulsion. Wet ink remains lawful, valid, and of course is more secure. To use it, you need to insist that your solicitor or conveyancer applies for an exemption under your state's rules. So in summary, everyone, wet ink signatures can still be used for property, mortgages and land dealings in Australia. While electronic conveyancing is the default, it is not the absolute. The law provides exemptions and consent to digital execution cannot be assumed. By instructing your solicitor and citing the ECNL and electronic transactions legislation, you can lawfully insist on wet ink execution. So all of the letters and templates and legislation I've stated in this recording today, I will put in the document kit that will go with this. If you would like the document kit, you simply need to go to warrioratlaw.org. Membership is completely free. It is a private organisation under international covenants, laws and treaties. And you go to the membership store area and it will be a free, completely free kit for anyone, any good living man or woman to use that kit. May take a couple of days to be up there, but with good intention and ease, grace and flow, we will get it up there as soon as possible. Any issues, send an email, admin@warrioratlaw.com. Wishing everyone a beautiful day. Speak soon.